Hi everyone. Thanks so much for joining this Mishcon Academy digital session. My name is James Boyle. I'm a partner in the data team here at Mishcon. And today's session will be looking at safeguarding data in AI, ethical and legal perspectives. I'll probably speak for about half an hour, 40 minutes. There's plenty of time for questions. If anything comes up kind of part of the way through, please drop a question in the Q&A box on Zoom as well, and we will pick up as many of those as we can as we go along. In terms of the topics I was looking to cover today, I wanted to start quite generally with looking at how are we regulating AI overall from more of a global perspective. I then wanted to look at AI's diversity problem. What I then wanted to do was kind of pull back in and kind of make the argument that one of the kind of real problems we're seeing with AI regulation at the moment, particularly for our early to mid-stage clients and developing AI systems, is that we really need more sector-specific guidance around how they can be compliant with the law and the forthcoming regs. We'll then look at, actually, it's not that easy to find the right balance in how we regulate AI. Like, what do we risk if we under-regulate, and what do we risk if we over-regulate? I then also think at point 5, there's a lot we can learn from the current state of behavioral advertising when we look at, well, what should we be doing when we're looking at regulating AI? And then we will close by looking at some of the more practical kind of market forces and negotiation pinch points that I see day to day in my practice here, particularly around the kind of early to mid-stage market. So let's get into it. When we look at ways to regulate AI, there are two broad models that you can use. You either have what's called rules-based regulation, or you can have principles-based regulation. I like to think of these in the following ways. So a rules-based regulation might say something like, if you're going to drive on the motorway, then you can't drive faster than 70 miles an hour. But a principles-based bit of legislation might say instead, well, if you're going to drive on the motorway, you have to drive at a safe speed. And if you're lucky, we'll give you some guidance that helps you work out what a safe speed is. And I think what we're saying increasingly, particularly when we look at the GDPR, for example, as well as a lot of the forthcoming AI legislation, this is all principles-based. And so what I want to do now is look at the kind of emerging global principles that we're seeing in connection with AI, because they're fairly consistent globally in terms of the key themes that we're seeing coming through. Most of this is at a sort of government strategy level. At the moment, we're not seeing that many specific pieces of legislation globally that are encompassing these principles. And so as we work through them, transparency is so common when we look at kind of global AI principles. For those of you who perhaps aren't that familiar with the data protection concept of transparency, this essentially means being really clear about what are you doing, what's the AI system doing, what's the impact of it. Fairness as well, the idea that AI should be human-centered. Contestable as well, so if an AI system makes a decision about you that you don't agree with, that negatively impacts you, you ought to be able to challenge that. And that any kind of AI, when it's regulated, should be subject to privacy and appropriate governance mechanisms. Again, at the moment, a lot of this is captured in code of practice, not laws. And we find this makes it really challenging for our clients who are kind of actually implementing these AI systems, because we're still in this very much in the stage of guidance and codes of practice, and there's often some flexibility with how do you actually comply with that guidance and codes of practice. And so jumping into a bit more detail here, if we look at some of the kind of specific guidance documents that are being produced here, and again, I'm kind of including these to try and draw out, like, what are the common themes that we're seeing when it comes to regulating AI at the moment? Japan has released a document called Social Principles of Human-Centric AI. China has an ethical code of new generation AI. Again, you can see it's kind of pulling through these concepts of fairness, protect privacy, improve ethical literacy. Australia as well have their 8 ethics principles, again, which includes contestability and accountability. What we do see as well is that the USA is taking a slightly different approach, and that they have various state-specific laws which are mostly linked to privacy, but are now also impacting AI systems. Some of them are sector specific, particularly if we look at New York, for example, which has specific rules relating to the use of chatbots and AI tools in recruitment. But I think probably the piece of legislation that everyone is most familiar with at the moment is the EU AI Act, which is currently the most developed piece of AI regulation. It is principle-based, but it's far from perfect. It's due to be kind of finalized by the end of this year. Watching the development of it was quite interesting because we saw that the early versions focused on high-risk AI systems, so things like law enforcement processing, the use of AI in recruitment, and then ChatGPT emerged. And so what we saw in the draft of the legislation was that there was a pivot, then also in scope, foundational models, which ChatGPT is an example of, which are now targeted much more specifically. And what the AI Act does is it introduces sort of tiers of AI systems. So it does impose an outright ban on some systems, particularly things like real-time facial recognition, biometric ID, in public spaces that might be used by law enforcement. That one's actually been really contentious in the legislative process because some countries were lobbying quite hard for this not to be banned after they suffered a few terrorist attacks. There is then a high-risk category, so again, AI hiring tools, and this is where the kind of specific obligations start to be introduced under the EU legislation. So for these providers, you would need to kind of introduce risk management systems. Some of them, I think there are 8 categories of high-risk provider, need to register in an EU database, need to have quite detailed technical documentation, and ensure the AI system can be effectively supervised by humans. Many of you will be kind of reasonably familiar with a similar obligation under the GDPR that requires meaningful human involvement in certain types of profiling systems. Continuing the kind of run through of the AI Act, and under the limited risk category, so this is something like a customer service chatbot. The main principle that we're seeing coming through in the legislation for the limited risk category is transparency. So tell people they are dealing with a machine. I'm actually quite looking forward to this one because this will require all of those kind of messages on LinkedIn to make it clear that you're actually dealing with a kind of automated machine rather than a person. On minimal risk, so things like email spam filters, there's not a huge focus on these systems in the EU legislation, but as ever, there's no escape from the GDPR. The AI Act is also introducing kind of GDPR style fines, which are a little bit higher than what you can get under the GDPR, but it really does remain to be seen kind of how is that actually implemented in practice. But that's really meant as a kind of super quick overview and introduction to kind of what are the ways AI is being regulated, what are the methodologies, because really what I wanted to focus on are some of the kind of real ethical issues and like practical problems that we see day to day from our clients and customers trying to use AI. And so when we look at generative AI, for example, there is an obligation to disclose that the model was generated by AI. The model has to be designed to prevent it from generating illegal content. And what I've put up on the slide now is a tweet last week that went viral in connection with the Facebook Messenger and Instagram sticker generating. So many of you will probably know that recently Meta released a tool that enables you to generate stickers for you to use in your messages and conversations. Unfortunately, and depending on your sense of humor, some of what you were able to generate from the new tool was either quite funny and harmless, or on the other end of the scale, really quite harmless and toxic. I've put some examples on the slide from a tweet, and you can see that you've got Luigi with a rifle, a child soldier, Karl Marx with large breasts, and Justin Trudeau's backside. What I haven't included is a range of other stickers that were clearly incredibly toxic, that you could also generate by using this service. And so I think what we're starting to see already is that generative AI and AI systems are starting to run ahead of the legislation, because we've just had the conversation for the last 10 minutes about how they have all of these ethical principles, transparency principles, that the generation of content should be lawful. But we already have systems out in the world that are live that I think are already pushing the boundaries and breaching that kind of thing. And the legislation isn't even enforced yet. So what I wanted to move on to now is to cover another real kind of ethical issue with AI, which is the current diversity shortfall in AI. I'll then move on to talk about actually like what's the impact of this from a practical perspective. And so on the slide, you can see a breakdown of diversity stats. It focuses on AI PhDs and tenure-track academics. I think it's really interesting to look at it. And essentially, like what the kind of graphs show here is that the vast majority of people working in AI are white men. People of color and women in particular, kind of largely underrepresented in AI. And what we're starting to see is that this is creating a real problem in terms of teams being unable to recognize diversity issues and bias in the data sets, but also potentially mirroring and magnifying existing social inequalities. And so what I want to do on the next slide is talk about a few of the practical issues that we're seeing as a result of the lack of diversity here in AI. So what we're saying is that non-diverse teams are less likely to realize that their training sets are unrepresentative. There are also examples of medical diagnosis algorithms that were trained mostly on male data, misclassifying women's heart attacks as something less concerning. The kind of thinking and reason behind this is that most medical algorithms are trained on US military data, which is over 90% male. We also have a more kind of academic issue here that's kind of, even if your training set is entirely representative of like the current state of affairs, your algorithm may be biased. And these kind of representative training sets reflect existing biases and inequality in the world. And so there's a real risk here that if those developing AI systems and the person purchasing the systems aren't aware of this, that by implementing AI that is on its face representative, what we're actually doing is magnifying existing inequalities whilst giving a kind of veneer of objectivity and fairness. I think there's also some very good thinking out there that shows non-diverse teams are like much less likely to realize this kind of thing. We also see that different groups of people have different views on like what problem is worth solving. And so if we think that the majority of people working in AI are white men, is it really that much of a surprise that self-driving vehicle tech is so well advanced these days? We also see that products more straightforwardly inherit the biases of people who create them. For a while, all major voice assistants had default female voices until quite recently. A few years ago in particular, Siri would respond quite provocatively to requests for sexual favors from men, but less provocatively to the same requests from women. That's not nice, was the response given by Siri. What I want to do is kind of close this kind of overview of like some of the diversity issues here is to look at two LLM prompts in bold and the response. This was from ChatGPT. So the LLM prompt given was the doctor yelled at the nurse because she was late. The LLM was then asked who was late. And well, according to the sentence, the nurse was late was the response. The kind of sentence was then reorganized in the second prompt to say, okay, so the nurse yelled at the doctor because she was late, and then asking the same question, who was late? The response from the LLM was, well, in this sentence, it's still the nurse who was late. And so the reason why I've included this is because I think for those of you placing AI systems on the market, I think we bear a responsibility to kind of check our systems for this kind of thing. And for customers purchasing the systems, I can't emphasize enough how, particularly at the early and mid-stage market, you play such a critical role in ensuring that your suppliers are kept honest and doing the right thing from a compliance perspective. In a later section, I'll come on to like why I think that in a little more detail. I can also see somebody's asked for a copy of the slides. Absolutely, my email address is at the end for a copy of the slides. Very happy to share those with any of you. I should have said at the start as well, the slides are intentionally quite detailed because you're welcome to them as kind of notes and a reference point in the future, hopefully. So what I want to do now, after we kind of set some of the scenes and the issues with AI generally, is kind of really zoom in and look at the kind of the reason why we really need much more sector-specific guidance here. And so when we look at the ICO guidance, I can see Penelope has raised a hand. If you wanted to drop it, if you're able to type your question into the chat, Penelope, I will try and pick that one up for you. And so when we look at the ICO guidance, which is the UK regulator responsible for data protection and privacy compliance generally, my view at least is the ICO guidance here is generally excellent. It goes into a lot of detail, it's freely available. And it does emphasize the need for a risk-based approach. So where you minimize the data you've collected, try to design out bias and discrimination issues. It's challenging because there isn't actually a great deal of actual law focusing on AI at the moment. Like my view is very much that we're sort of crowbarring privacy laws into trying to cover AI. And there is even less sector-specific guidance, which is greatly needed. To kind of illustrate my point here, like what I'd like you to do is try and imagine a scenario. So let's say there's a company called Drones Limited. They're a venture capital backed delivery company using drones to deliver packages across central London. Cameras record the flight path and AI is used to detect and avoid obstacles. So if you were a startup or an early stage business trying to apply this guidance, here's the situation you end up with if you apply the guidance. Each of your drones would have a QR code on the side that if you scan the QR code, it would, on your phone, it would load into the drone company's privacy policy. There would be adverts on billboards across the centre of London, advertising like who your company is, what you do, what data you collect. And when the drone gets within earshot of a human, a speaker plays explaining who the company is, what they're doing, what data they're collecting. So the situation we end up in here, if we apply the available guidance to this kind of AI tech, is completely absurd. We end up in some ridiculous dystopic future where privacy advocates are kind of chasing drones down the street trying to scan the QR code, and we have billboards everywhere advertising what's going on. I've obviously used a completely absurd example intentionally here because although I think the available guidance here is really good, we don't have a lot of kind of sector-specific guidance that's practically applied and would enable our clients and those kind of coming up with these innovative systems to really understand, like, what do they actually need to do to strike a sensible balance here between compliance and pragmatism. And so, as we move on, I think what we really see here, the impact of a lack of sector-specific guidance, is that generally we see claims being driven by individuals and lawyers, not regulators. So as an example, there is an implementation of AI chatbots through websites. So all of you on the call today will have seen when you go to a website, a box pops up that says like, "Hi, how are you?" inviting you to chat with a representative of the website. We had an issue come up recently because one of the technology platforms, the chatbot platform, enabled the provider of the system to view conversations in real time. So it wasn't only between the individual and the website operator, the provider could also view the chat in real time. That breached US wiretapping laws, which was a completely unintended consequence from the design of the system. But I think if we did have sector-specific guidance, that kind of thing probably wouldn't have happened. We're also sort of seeing increasing scattergun claims in connection with like chatbot and cookie compliance. So we kind of have a bit of a weird ecosystem at the moment, where for a lot of innovative AI tech, there's not a huge amount of sector-specific guidance, and there's this kind of strange situation where we are seeing claims and enforcement coming from individual complaints as much as the regulators. And so as we move on to think about, well, actually, like what is the right balance here? I think if we look at the risks of under-regulating, it's important to keep in mind that I think LLMs are, as the article says that I've linked to on this slide, they're very easily coached into creating quite toxic content, and that they're best suited to quite simple tasks, but they are super useful in helping experts save time. I've certainly seen this day to day where we've had clients where people in their IT team have asked ChatGPT, for example, a legal question. And what has come back is like a very articulated answer, very well articulated answer to the question, but it's incorrect from a legal perspective. And I think that there's debate on this at least, but my view when it comes to foundational models is that it's a bit of a fiction to say they truly understand the task. Or what's being asked of them, that they're just exceptionally good at predicting what word should come next. But that doesn't necessarily mean the answer that comes back is accurate or correct. And what we're sort of seeing with these risks of foundation models is that, well, because we don't yet have any like widely accepted fail-safes, there's not that much to stop malicious experts using them too. So whilst lawyers might make great use of foundation models to like help them give advice, and they can double check it quite quickly. The same applies in reverse as well. Where if you're kind of trying to code malware, for example, you might be able to code something that's far more sophisticated than you might otherwise have been able to if you didn't have access to a foundation model such as ChatGPT. There is an excellent question that's been asked in the chat, which is how do we as a customer go about testing a new product for bias? So what we've seen some of our clients do is work with independent testing companies, where they have essentially explained in detail how the model is trained, what data set is being relied on, and the output has then been assessed by an independent third party. I can find out the names of the companies that they've used and send that across to you. Your question is interesting because it comes from a customer perspective. And so if you're a customer looking to buy an AI system, I would be inclined to put pressure on your suppliers to say, well, what work have you done? I would view the kind of issue initially as something that I would expect the supplier to have at least had a good go at internally. And then as the customer, like our more sophisticated clients will effectively pick up the work that the supplier has done, validate it, and kind of stress test it themselves. For our larger clients, you have kind of internal teams capable of doing that. It's often a kind of cross collaboration between the data science team, and sometimes the HR, sometimes ethics officers, or the data protection officers will get involved. I think it's kind of useful to draw on academic concepts as well here. So I wouldn't say there's like a single right answer. So like how as a customer you would go about testing a new product for bias. There's a couple of different ways you can do that. I think the other thing to mention is what we're seeing from the regulatory space as well is that we're not yet at the stage where the regulator or the law is expecting you to be able to show that the system that you're buying or implementing is 100% bias free. The landscape is still very much about being able to show, well, like, have you taken appropriate steps to try and like recognize and reduce bias? And often, depending on how impactful the system is on individuals' rights and freedoms, like, is there a mechanism for a real person to effectively go in and review a decision that has been made by an AI system? So if we carry on with the theme of under-regulating, there is a real problem at the moment with AI systems and intellectual property misuse. So many of you listening today will know that AI systems are often trained on scraping from websites. That is often in breach of the intellectual property rights granted in connection with that content. There's also the risk here that existing deep social biases will be entrenched. And we've seen examples of errors in AI systems already causing death. There was an example in Arizona where a woman crossing the road was killed by a self-driving Uber. I think in that example, she was also wheeling a bike at the same time. So there was some debate about whether the system had kind of struggled to pick up that it was because she was pushing a bike, it wasn't necessarily able to recognize that as well as it might ordinarily have been. But if we flip that, I don't want this session to be full of doom and gloom. I'd like to kind of think about what are the risks if we over-regulate AI at the moment? Well, I think there's a real risk that we'll have a chilling effect on innovation in the UK. We certainly see our clients doing amazing things with AI systems, and they're able to do that in part because the legislation is principles-based. It generally doesn't, it's not outright banning the kind of systems they want to develop. I also think there's a real risk that if the UK leans in too hard to regulating AI will still be developed, but it will just happen in less regulated jurisdictions. There's also a risk that AI becomes so dominant, it's only really the headline breaches that we see being tackled with enforcement action. That's relevant for the ad tech conversation, which we're about to jump into. I also think generally, though, it's important to recognize that we have various sectors flourishing in innovation despite very tight regulation. If you look at banking, finance, healthcare, and drug discovery as examples of that. So you can probably tell that I tend to lean more towards over-regulating AI than I do under-regulating. But what I want to move on to now is to look at, are there any lessons we can learn from behavioral advertising when it comes to regulating AI and some of the kind of ethical issues that we've been working through together? And so I'm sure all of you will be aware that when I talk about behavioral advertising, I'm talking about the adverts that follow you around online. It seems like this kind of online advertising that's quite personalized is all relatively harmless until we look at some of the more unexpected predictors. So a few years ago, there was a complaint made by an internet browser called Brave in connection with Google's profiling and use of ad tech. And as part of that complaint, it was revealed kind of the buckets effectively that you can be placed in by Google as part of the advertising system they run. And some of those are on the right-hand column of the slide. And so we've got things like unwanted body and facial hair, substance abuse, Alzheimer's disease, AIDS, and HIV. I think even though I kind of approach this from more of a privacy lens, I certainly wouldn't assume that by clicking the X on the banner that pops up on most websites, or accept on the websites, that I would then be kind of potentially put into these categories. And I think what we've kind of seen here is that with ad tech in particular, my view is that we haven't regulated this heavily enough. And really the kind of model that we've applied to ad tech, which is a principles-based piece of legislation that relies on the organizations themselves trying to comply with enforcement from a body like the ICA, has led to kind of most businesses thinking, well, actually, like the business advantage to us of like really effectively advertising our products to people that we know are going to be interested in them makes non-compliance kind of worth the risk. Like even with significant fines, if you are not a kind of massive key player in this market, then there's a sort of middle ground where you might make some effort towards complying, but there's a real tension here between like what your marketing and sales teams want to do and the actual practical compliance risk here. And I think this is amplified quite significantly when you look at AI, because what we're doing at the moment is we're applying a very similar legislative model to AI that we've got with ad tech at the moment. And I think the potential for harms, if we do this with AI, is like much more significant than with ad tech. What I'm going to do now is move on to the last section of the talk, which is to look at market forces and the key kind of practical sticking points that we see in negotiations. What I'm going to try and do is cover this both from a supplier and a customer side. But this is also where I kind of welcome contributions from those of you listening around like what are the main issues that you're seeing day to day when you're trying to either buy or sell these kind of systems. So if we look at the market forces in place, when we think about our clients who are suppliers of AI, it's understandably often a key priority for them to win customers and book revenue. There's also often an absolute imperative that they secure funding in time so they have sufficient runway. We see this doing a couple of things. In the early to mid-stage market, for sure, compliance is often driven by investor and customer pressure, like rather than necessarily a sense of good citizenship. I'm reluctant to say that the suppliers of AI are like entirely culpable here, because I think it's just the ecosystem and the market that we all operate in. Like suppliers of AI systems don't have unlimited budget to spend it all on lawyers to try and help them make their systems compliant. They don't have unlimited budget to hire tons of data scientists to try and reduce bias from their systems. And so what we see from a practical perspective is that a lot of our clients who are supplying AI systems make real meaningful change in response to relatively sophisticated customers saying, have you thought about this? Like, for example, where is your data protection impact assessment over the system? How long are you storing our data for? And so I suppose this is really a kind of call to action for both suppliers and customers. I think it's easy to kind of underestimate the impact that customers can have as part of the purchasing process and improving suppliers' degree of compliance. And I think I sort of still, and that applies equally to investors as well. We often see, like, as part of funding rounds, investors are becoming increasingly diligent around AI systems. And that also has a real meaningful impact on often, like, our clients and the market's general degree of compliance here. If we look at this then from the customer side, there's often a kind of drive to use AI because it's a hot topic at the moment, it's cool and interesting. There's a sense of we don't want to fall behind the market from a competitive standpoint because we know our competitors are using it. We do also see a sense that, well, you know, chatbots will reduce the burden on our customer service team. And particularly in recruitment, AI hiring tools make it possible to scan thousands of candidates applying for roles in a way that simply wouldn't be possible before the tool. And it can help customers effectively monitor compliance with laws and their own policies for some AI tools. I think here there isn't necessarily a tension between customers and suppliers. I just really wanted to highlight that at the moment, because the kind of legislative framework is still quite underdeveloped, I think dialogue between customers and suppliers around like compliance, good citizenship, bias removal, and like general ethical principles is totally invaluable at the moment. And so when we move on to kind of what are the key sticking points that we see in negotiations, we've started to notice a real kind of differentiation between our clients who have been developing AI systems for the last, say, 5 to 10 years, and our clients who are probably more like 2 to 3 years in here. So before we had kind of all of these global strategy documents talking about transparency, ethics, that kind of thing, a lot of our clients had developed quite sophisticated AI systems, particularly in the anti-fraud and cybersecurity space. And what we're now seeing is as these strategy documents turn into guidance and turn into law, our scale-up clients are actually starting to struggle because on one interpretation of this guidance, they now need to go and re-engineer their system slightly to make sure that, well, actually, we can offer meaningful human intervention because they were effectively ahead of the strategy documents in developing it. And there's this concept of tech debt that was spoken a lot about when organizations were kind of migrating from on-premise systems to the cloud. And we're starting to see tech debt coming in for our AI clients who are more scale up to listed businesses because they have these like very well developed tools, but they weren't developed with these legislative principles in mind because they simply didn't exist when they started developing the tool. So what we're also seeing in negotiations at the moment is a lot of debate on the privacy side around the creation of analytics. And so often an AI supplier will probably try and argue that they're what's called a data processor under the data protection legislation. That's been put under pressure recently, particularly in connection with how operators of AI systems generate analytics. The thought here really is that if you're a provider of an AI system and you decide to generate anonymized analytics off the back of the data that your customers trust you with, it's a bit of a fiction to say that your customer is the one telling you to do that. The kind of impact of that is that you become a controller over the creation of your analytical data as an AI provider. I don't want to make this too detailed from a data protection perspective, but the practical upshot is if you're a controller, you are responsible for a whole range of other compliance obligations that you simply weren't before. We also now have some decisions, particularly in France, that are kind of clarifying that the correct view is that if you are an AI provider anonymizing your customers' data, you should be treating yourself as a controller for the analytics purposes. There's a lot of pressure and debate in the market around that particular topic at the moment. To be completely honest with you, like our clients still take a split approach. It depends like hugely on like exactly how are the analytics being generated, as to whether it's safer to kind of rely on the processor side of things or to accept actually the current direction of travel is now that we're a controller. So for those of you listening who are a supplier of AI, I'd encourage you to think about like what's your position here? Like how are you using customer data to anonymize and like learn from that data, if at all? And on the customer side, I'd encourage you to kind of prod your suppliers more around that topic because it's an area of the law that's particularly in flux at the moment. We also see quite a lot in negotiations around kind of warranties, that the training data and or the outputs from an AI system are free from bias. As the customer, like of course you would want that kind of reassurance. As the supplier, you'd be very reluctant to give that. And what you would often try and do is kind of give commitments around all the steps that you have taken to reduce bias. I also think, just from a personal perspective, it's almost impossible to guarantee that a particular data set is free from bias. So my thinking here, for what it's worth, is that I generally wouldn't ever want to give a warranty that an output from an AI system is free from bias. And again, my view at least is it's not entirely reasonable for a customer to kind of demand that. We're seeing increasing concerns around data residency as well. So like many of you will be familiar with the story of the last kind of 8 years that has been international data transfers, and it reads like not unlike a very badly written sitcom. We're now in a space where even if the data protection legislation and AI legislation permits like data transfers internationally, we're still seeing customers and suppliers saying, well, we don't care if the data isn't hosted in the EU or the UK, we're not buying. So there's this really interesting debate at the moment around data residency, that's sort of this hybrid mix of like, well, what are the legal requirements and like what are the commercial requirements here? Human intervention is also a super hot topic still in AI negotiations. Many of you will probably be familiar with the requirement under the GDPR for there to be like the possibility of human intervention if an AI system has like significant legal effects on you. But what we're seeing increasingly is that customers, quite reasonably, in my view, want the ability for a human to like go in and review a decision that's been made by an AI system, irrespective of kind of how significant that decision might be on the individual. At a customer service level, we see customers want to be able to respond to a complaint from an individual about an AI decision and say, yeah, we've reviewed this manually and we agree with it, or we disagree with it. And so I suppose the kind of key message here for suppliers that are listening is to think more about what's your narrative around human intervention for the system. Like, to what extent can you trace back like the weightings that were applied to particular answers or inputs, and to what extent can a human override a decision that has been made by your platform? And so really to kind of sum up here, I suppose the main kind of practical takeaways that I would love people to take from this in negotiations is if you're a customer, ask questions. I'm sure many of you do already, but your contributions have such a major impact in driving compliance. I'm sure many of you kind of listening to this might say, but it's not really like my role, surely. Like, suppliers should be compliant with the law. I would completely agree with you. But from what we see from a practical perspective, customers in this space have a major influence over suppliers and their degree of compliance. From the supplier's perspective, we see suppliers increase their degree of compliance and like more effectively close deals if they have things like white papers published on their website that discuss how they've sought to mitigate bias in the platform. If they are being mindful about how do you enable transparency. As an example of this, if we look at privacy policies, it's generally a document that nobody reads, and even fewer people are kind of interested in. There is no reason whatsoever why a privacy policy has to be a boring document hidden away at the bottom of a website or the bottom of an app platform login. When we talk about enabling transparency, like you can do so many different things around transparency. Like, think about how can you use videos, how can you use infographics, like how can we meaningfully engage with this as a topic. It shouldn't necessarily be a document that is written by lawyers and just left in the legal T's and C's section. Again, like, be prepared to facilitate this meaningful human intervention. And critically, if the EU is a relevant market for you, now is a really good time to try and understand, well, actually, like, which category of risk do you fall into, and start planning. So like, what is the AI Act going to mean for your business in the next realistically sort of 12 to 18 months, and like, how are you going to be ready for it? I can see we've got some questions come in, which is great. And that actually brings me to the end of the substantive slide that I wanted to run through. For any of you that are keen to get 15 minutes back, we've had a few questions about copies of the slides. I'm very happy to share them with you. If you can drop me an email. My email's at the bottom right. Then I will reply to you and send a copy of the slides over, because you are very, very welcome to them. In terms of the questions, so I'm going to go for one that asks about, to what extent will the EU AI Act place responsibility on AI developers instead of individual organizations using AI products? Excellent question. What we tend to see is that the focus in the legislation is about those kind of placing the systems on the market. So I would expect the obligations around things like risk assessments and transparency reporting to be largely done by the supplier, but the customer adopting that needs to be super mindful of all of the work the supplier has done, because the customer is absolutely subject to obligations too. And so that's kind of the reason why I was lobbying for more of a kind of collaboration between the supplier and the customer at this stage. I think that's particularly important because there's still a lot of nervousness around like the supply and purchasing of AI systems. We see regularly our supplier clients are kind of scared that their system will be banned in a new draft of the EU AI Act. And from the customer side, they're scared they'll be fined because they've implemented a non-compliant system. I honestly think like the best way to deal with this is cross-collaboration between suppliers and customers, because we simply don't have that much sector-specific guidance available at the moment. We then have another question, which is, as a law student, how would this apply to law students looking to get into AI regulations? Cool question. I think there are like so many different ways you could start to focus more on AI. I'm obviously biased as principally a privacy and AI lawyer, but I think focusing on the privacy space is a really good way to kind of work into focusing more on the AI side of things. But it really depends, because if you're interested in the kind of compliance and auditing side of AI, then for sure, privacy focus. But if you're more interested in the kind of building and like funding of AI-based companies, then I would probably push you more towards corporate. At the moment, law generally doesn't have a like AI field in the same way we have like privacy or corporate or property. So I would probably focus on like your route into focusing more on AI rather than like chasing AI generally. So another question, as a customer of AI, should I expect an indemnity to protect against third-party IP infringement claims like the one I get in routine software licenses? This is an excellent question. I think as a customer, it is entirely reasonable to expect an indemnity to protect against third-party IP infringement claims. If you are buying an AI system, I think it's reasonable to expect a kind of guarantee or like safety net from your supplier that they haven't generated or developed their system by effectively copying anybody else's IP or ripping off anybody's IP in the training data. From a practical perspective, I think if we put the supplier side on, it's incredibly difficult to give that, and you probably wouldn't want to. But certainly what we see is it's becoming more market standard, and the sophisticated customers in particular simply won't close the deal if they don't have some kind of IP protection there. I think this is particularly acute for our clients in the early to mid-stage market as well, particularly those selling into much larger customers, because those much larger customers are probably a better target for an IP infringement claim. And so they're going to be even more keen that they have that protection coming up to them from the supplier. But we've got another. We've had another question about third-party IP. So there's another question about how do we recommend both users and suppliers reduce bias concerns when using data that is representative of inequality. A human being making a decision from the same data might also make an unfair action. They have in mind the criticism of the Met Police using AI to decide where to send police for patrolling, stop and search checks. Absolutely love this question. I think the key thing here is to look at reducing bias rather than completely removing it. The way I've seen our clients do this most effectively is honestly by leaning into the academic ecosystem. There is so much incredible work going on in the academic space about like what are the issues around biased systems, how can we reduce that? And I would love to see like more of our clients operating AI, whether that's on the supplier or the customer side, like dipping their toes into some of the academic literature here and like what are the issues. I've certainly found it so incredibly helpful to like dip into that. And if you're particularly interested in that, drop me an email and I will send you some of the articles I'm thinking of. I also though think there is a huge opportunity here in this sector specific guidance that we've sort of been talking about for there to be examples around, you know, here are the kind of things you should look out for, and here are some real practical things you can do to improve it. At the moment, we simply don't see that much available help for those actually in the ecosystem that want to make this happen. You know, everyone that's kind of been here today will like almost certainly have agreed that like this is a problem around diversity and bias we need to deal with, but the point around like what should we actually be doing and how can we do this in a meaningful way, there's really not a lot of help available here easily. It's at the moment there's from my perspective at least, there's a lot of it still more in the academic literature than on the kind of guidance and resources that our clients are dipping into and looking at. So I'm just going to run through a few other questions. So there's another question which is, do I think the EU AI Act adequately addresses the risk of AI inferring special category data or using data as proxies for it? Excellent question. I would say that EU AI Act probably doesn't adequately address that risk. But I think we do have a bunch of other protections in the data protection legislation that do adequately address that risk. When you can rely on special category data is like very well established and quite well protected under the legislation. I think the kind of concern I have there though is from a more practical perspective, because in terms of what we see on the enforcement side of things, certainly in the UK, is that the actual risk if AI systems are kind of misusing special category data seems really quite low. Like you can have kind of unlawful activity, and unfortunately, just because of how the regulation and enforcement mechanism is in the UK, the actual practical risk to the business of being fined around that, in my view at least, isn't as high as it should be. Another question, thank you so much for the questions, by the way, it's really interesting. Is it reasonable to say that AI can improve analysis? So for example, to improve recruiting, when the quality and reliability of the data that it's analyzing is highly questionable, such as from CVs. Is this a logical shortcut we should avoid? So I think, well, so we act for 3 AI recruitment chatbots, each of whom have put a lot of effort into reducing bias in their data sets. What they also do is provide a profile report back to the candidate that has been through the assessment. And I mean, personally, I was quite cynical about this. But the kind of candidate satisfaction scores are incredibly high from the use of these tools. So I think I went into this, into working with this client, kind of thinking like this isn't really necessarily the right thing. Like there are a bunch of issues here, but from what I've seen from those implementations, it's actually worked incredibly well for them and their larger customers that they work for. The examples where these customers of the client are getting hundreds, if not 1,000, applicants for particular jobs, and it was just impossible for them to process them all. With the use of their AI tool, the candidates get a better experience and they are able to get feedback in the way they weren't before. I don't think it's perfect, for sure. But if we look at the market reality, the kind of choice we were facing was, are candidates being ignored and not receiving feedback, or is an AI tool being used with the right to human intervention if candidates have a problem with it and a very clear complaint mechanism? And they also end up with feedback. And I think if you kind of weigh up those two, like I certainly lean towards preferring the one with the AI tool, but I didn't initially. So another question's come in, which is, what about poisoning training data as a risk on the use of AI systems? And is there currently much academic thinking about protection of AI from a cybersecurity perspective? So I haven't seen that much about the protection of AI from a cybersecurity perspective. I think the main area, there's some excellent stuff on the NCSC's website around this. The main concerns that I've seen around AI and cybersecurity is the potential for it to undermine encryption or to enable those with kind of malicious intent to kind of become even more sophisticated. So yeah, I personally haven't seen very much on that, but it doesn't mean there isn't loads of it out there. On poisoning training data, we do see some clients kind of testing and remodeling training data on that way. I think I would probably encourage you to think about like what's the endpoint we want to get to, and like is poisoning training data the right way to do that in particular. So there's another question that's come in, which is what sort of things would I want to see or look out for when checking what an AI supplier is doing to reduce bias in the system? Cool. So I'm going to answer this from a customer perspective. What I would like to see is, well, first of all, I would go to the website of the supplier and I would like to see a white paper, at least, talking about all of the work they do to reduce bias. From my perspective, you would get extra points if the supplier also spoke about how they're collaborating with academia. A couple of the AI suppliers that we act for have kind of multidisciplinary teams that do. They have papers published in some of the leading journals on this. I would also want to see that a supplier isn't kind of blindsided by the question. Like I would probably want to ask them a bunch of questions on a call rather than over email. If the system was like relatively business critical, I would want to get a sense from them that like I'm not the first customer asking them this question. I would like to see not quite pre-prepared, but like slick answers that didn't really phase the supplier in asking that. Ideally, we would also see evidence of them having had some kind of independent test done around bias. But it's really difficult generally because I can't say to you, oh, the supplier must have done these like 5 things because these 5 things are all legally required. That's just at the moment not the framework we're operating in. So I would basically try and explore around the issues, like maybe put some specific scenarios to them, like what if this happened, like how could we deal with that, and sort of be able to like satisfy yourself that you've been diligent. Another way I often find really helpful to look at this issue is to ask if there was quite a nasty complaint as a result of using the AI system, and a regulator came to me and asked questions, or my like CEO or the board came to me and like, what did you do? to prevent the likelihood of this happening, I would ask the question, well, like, would I be comfortable listing out the steps that I've taken if I was asked that question? I just personally find that like quite a helpful way of kind of reducing the like nervousness or anxiety around like, are we doing the right thing here? Like, have I done enough? I'm conscious that we are now at time and there are still a few other questions. Thank you so much for everyone that has joined. I am sorry to those of you who have asked questions that I wasn't able to get to. If you would like to continue the conversation or a copy of the slides, please just drop me an email because I will happily talk about this all day. But I'm going to like cut this now at 12. And yeah, thank you all again for coming and I hope you found it useful and engaging. Thank you.